Okay, let's unpack this. We are diving into a monumental legal battle that has just taken a really dramatic international turn. It's all about the catastrophic 2015 Samarco dam collapse in Brazil, a huge tragedy involving some of the world's biggest mining companies. But the bombshell ruling, it came down not in South America, but in a London courtroom.
And that London ruling is precisely why this matters on a global scale. Our mission for this deep dive is to really understand the legal weight of this decision. The court found the global mining giant BHP Group legally liable. We're talking about a claim that could lead to one of the largest corporate payouts in history. About 600,000 Brazilians are seeking, roughly 36 billion.
36 billion pounds?
Yeah.
It's a staggering figure, and that's the immediate context. So here's the core conflict. A London High Court judge, Finola O'Farrell, just ruled that the Australia-based BHP was responsible, and that just clears the path for this massive financial claim. It's an incredibly powerful precedent.
It's a truly astounding development. I mean, it forces you to look at corporate governance, at liability across borders. But before we get into the legal fine print, you have to understand the scale of the original disaster, because that's what justifies the size of this claim.
Exactly. Let's start right there with the facts of the catastrophe itself. This all happened on November 5th, 2015. The Fundell Dam, which was used to hold mining waste, it ruptured. Near Mariana in southeastern Brazil, 19 people were killed almost instantly when this torrent of mined sludge just swept through. Entire villages, like Bento Rodrigues, simply wiped off the map.
And we really have to clarify the ownership structure right away, because that's what makes the legal case so intricate. The operator was a company called Samarco, a Brazilian company, but Samarco is a 50-50 joint venture. It's owned equally by BHP, the Anglo-Australian giant, and the Brazilian company Vale. So when the disaster struck, the blame immediately stretched across continents.
The human toll was just tragic, but the lasting environmental nightmare. That's what truly sets this apart as Brazil's worst environmental disaster. And to help you visualize the scale, the sources point out that the sheer volume of mine waste released was enough to fill, get this, 13,000 Olympic-sized swimming pools.
13,000.
Think about that volume dumped directly into the ecosystem.
And that volume of toxic waste was just unleashed into the Doce River. It contaminated what is, essentially one of the country's main arteries. We have some pretty precise metrics on the destruction. We're talking 14 tons of freshwater fish killed and 370 miles, that's 600 kilometers, of the river severely damaged.
And beyond the sheer physical devastation, there's this immense cultural context. The Doce River is revered by the Krenek indigenous people. For them, it's a deity. The sources really stress that nearly a decade later, that river has not recovered.
Yeah.
This is lasting cultural and ecological devastation.
Which is exactly why the legal action had to be so robust. It's trying to address a level of harm that, that money almost can't fully repair.
This brings us right to that landmark London ruling. A disaster in Brazil,
right.
A Brazilian company, but a UK judge holds the parent company liable. I think a lot of listeners will be scratching their heads. Why Britain? Was this just lawyers finding the most sympathetic venue?
It's a little more technical than just pure sympathy, but while that element is certainly a factor, the plaintiffs specifically targeted Britain because one of BHP's two main legal entities. It was headquartered in London at the time of the collapse. That legal fact, that's what allowed them to argue successfully that the London courts had jurisdiction.
Okay, so they found the legal hook. But the ruling didn't say BHP owned the dam or even operated it directly. Samarco did that. So what was the core legal reasoning in Judge O'Farrell's, 200-plus page judgment? How did she find BHP responsible?
The entire judgment, it really hinged on one concept: foreseeability. This is the crucial legal nugget for anyone interested in global corporate accountability. The judge ruled that the risk of collapse was foreseeable. The evidence showed there had been obvious signs of contractive saturated tailings and numerous incidents of seepage and cracking.
I'm still struggling a bit with that. I mean, doesn't every company operating a mine know there's some risk of failure? What made this case legally different?
What made it different was the documentation proving the avoidability. The judgment essentially said that BHP, as a joint venture owner, had the institutional knowledge, they had access to the safety reports, they had the ability to intervene and mitigate these known risks, even if Samarco ran the day-to-day. The judge's conclusion was blunt. The collapse could have been averted.
So the finding isn't about, say, active sabotage or even negligence on the day of. It's about knowing a ticking time bomb existed and having the power and responsibility to defuse it, but failing to do so. That makes the parent company responsible for oversight.
Exactly. By establishing that the risk was known and avoidable, the court set a massive precedent. It's a huge win for those 600,000 claimants.
That is powerful. Now, let's be absolutely clear for our listeners. This ruling, it only established legal liability. It doesn't mean the $36 billion payout is hitting bank accounts tomorrow, right?
Absolutely not. That is a critical distinction, yes. The ruling only addressed phase one. Yes, BHP is responsible. The second phase of the trial, which still has to be scheduled and fought, that will be about the damages, the amount of money actually awarded. That's where we'll see the final tally.
A final tally that could, in theory, exceed 45 billion US dollars. Which brings us to a really complicated part of this case. The parallel legal track, the one running in Brazil.
That's right. And that's where things get really interesting. The UK trial, amazingly, began only days before the Brazilian federal government reached its own multi-billion-dollar settlement with the mining companies, with Samarco and Vale specifically.
Okay, so let's anchor the financial figures here, because there are two huge sums. We have the $36 billion being sought in London from BHP, and then this separate, already established settlement in Brazil. What were the terms of that Brazilian agreement?
So under that Brazilian deal, Samarco and its half-owner, Vale, remember BHP is the other half, they agreed to pay 132 billion reais. That translates to about 23 billion US dollars over 20 years. That money is specifically for human, environmental, and infrastructure damage within Brazil.
So we have the Brazilian government getting a $23 billion commitment from Vale and Samarco, while at the same time, 600,000 Brazilian citizens are chasing potentially double that amount from BHP in London, which explains why BHP is fighting the London action so hard. What was their main defense?
Their defense was strategically very simple. They argued the UK legal action was unnecessary. Their point was that it duplicated matters already being handled by the settlement and legal frameworks in Brazil. Why waste the court's time?
That actually sounds like a powerful argument.
Yeah.
If $23 billion is on the table, why should a UK court get involved? Why did the London judge reject that? That seems to be the crux of it.
Well, the judge's decision to keep jurisdiction sends a massive message. It implies that she did not believe the compensation available through the existing Brazilian processes, either the federal settlement or local lawsuits, was sufficient, or that it provided the same level of legal remedy that the claimants deserved.
So the judge essentially said, just because there's a compensation track in Brazil doesn't mean it's an adequate one. The London action offers a distinct path to justice.
Precisely. It's a powerful statement about the perceived effectiveness of local versus international legal systems when you're dealing with this level of global corporate wealth. Now, BHP intends to appeal this liability decision, citing that very duplication. But for now, the judge has emphatically ruled the UK group action is essential.
So this whole story, then, is a powerful example of a global mining company being held legally liable in a foreign court London for a disaster caused by a partly owned affiliate, Samarco. And it's all based on that key legal principle of foreseeability.
It is. And if we connect this to the bigger picture of corporate responsibility, this case is a massive red flag for all multinationals. You have two parallel compensation tracks, one from a government settlement and one from foreign litigation by citizens. Both involve astronomical amounts. And this raises a really important question for further thought. Given the complexity, the expense, and the potential duplication of these two massive legal actions, what does this case imply for how global companies will manage risk and liability across different international jurisdictions moving forward? Will boards now have to factor in the cost of defending simultaneous multi-billion-dollar lawsuits across separate continents?